Hello, my name is Dr. Vishwas Devaya. I am an associate professor at Jindal Global Law School, Sonipat. Today we are going to focus on philosophical justifications of intellectual property rights. The presentation will be structured. Firstly, we will be discussing utilitarian theory. Secondly, we will be discussing about the Lockean labor theory, and thirdly, we will be looking at Hegel's personality theory. Before we actually begin with the utilitarian theory or utilitarian justification of intellectual property rights, it is important to raise certain questions. What are these questions? These are basically, should we actually treat intangible property rights like trademark, copyright and patent law as property rights? Why should they be granted protection at all? Are they equivalent to property rights? All of this, to find an answer for this, we'll actually basically have to look into the philosophical foundations of intellectual property rights. To do so, we'll be basically looking at a number of theorists like John Stuart Mill, John Locke and Hegel, who actually came up with certain theories in a completely different era, but they were not necessarily forwarded with intellectual property in the mind as such. They were largely kind of foundations of philosophical visions presented by these various philosophers at various points in time, linking it to the political times in which they lived. But a lot of academics have actually utilized these philosophical theories espoused by them to justify intellectual property rights. So let's begin with the utilitarian theory of property. Firstly, let's begin with John Stuart Mill's justification of utilitarianism. John Stuart Mill was the person who espoused the utilitarian theory. Stuart Mill actually said, an act is said to be good if it results in the greatest good for the greatest number of people. Now, Mill was not the first person to actually talk in terms of consequentialism. It was basically Jeremy Bentham who actually kind of started with the utilitarian theory, but Stuart Mill actually kind of modified and said an act would always be good if it results in the greatest good of the greatest number of people. Now, how do you calculate whether a particular act is good? Now, Stuart Mill said you have to basically count the amount of happiness a particular act causes and the amount of harm a particular act causes. If you weigh the harm against the happiness, if the happiness outweighs the harm, then basically such an act would be a good act. But if the harm actually outweighs the happiness, then such an act should be discarded because it is a bad act as such. So, as far as Mill's utilitarian theory is concerned, if it results in the maximum happiness of the maximum number of people, then such an act would be good, right? Now, how can you actually use this theory to justify intellectual property rights? Now, Stuart Mill says maximum happiness of the maximum number of people. Now, if you look at intellectual property rights as such, if you look at patent, for instance, take patent as an example. Now, the patent system awards or grants what is called as monopoly to the inventor, and the inventor kind of enjoys a monopoly for a period of 20 years. How could this actually be good for the public? Now, utilitarians would actually say, let's look at a particular invention. Does it actually cause good or does it actually cause harm if we grant a patent? Now, utilitarians would say the end result of granting patents would be actually good for the society. Now, how will they calculate the happiness and harm, basically they look at what is the end effect of actually protecting new inventions. If new inventions are not protected at all, that is, if you do not grant any monopoly, then any person who actually comes up with a new innovation will basically not come forward to tell or announce in public that he has come up with a new invention. In fact, they largely kind of hide their innovations because they believe that they have put in the hard work to kind of come up with an invention, but it is largely the others who hear about the invention who would actually kind of replicate their innovations. That in the sense basically means if a person has invested a certain amount of time, money, labor in actually coming up with a new invention, a person who actually hears about that invention would actually replicate in a short period of time and possibly make profits. This would actually hinder a person who has come up with an innovation to come out with that information if there is no protection for his innovation. But if you look at the other way around, that is, if a patent is granted and monopoly right is given to the innovator, that basically means the innovator enjoys protection for a certain period of time wherein he can actually practice his innovation, wherein he can disclose how the innovation is created, and at the same time recoup the money or invested amount during the period of the monopoly as such. Right? So, Mill would in fact agree that patent monopolies would be appropriate because it actually rewards a person who has actually worked on a new innovation. If innovation is not protected, then the person would actually not come forward. That basically means the public would lose out on an innovation being made public, innovation being publicized. To give you an instance, a number of companies have secret formulas. Now, these secret formulas are basically secret because they think that the moment it is actually disclosed, and if there is no protection granted to the disclosure, then others would actually start to make these products and they would also be competing with them in the market, which may reduce their profit or the margins, etc. But if protection is granted, then a number of innovators could actually openly disclose these formulas, which can enable the public to learn about new innovation. It also allows downstream innovators to actually come up with modifications to a new technology as such. Right? So, in effect, the utilitarians would say granting patent monopoly is ultimately a win-win situation because it actually increases the greatest happiness of the greatest number of people. Similarly, the utilitarian theory can be used to justify trademarks as such. For instance, let's take the fact that there is no trademark protection. If there is no trademark protection at all, then people will actually be confused as to which product is sold by which manufacturer. Now, this is a fairly important aspect of consumption because consumers would generally like to kind of buy products which are safe, which are actually maintain a certain amount of quality. Now, if there are no marks on a particular product, then possibly the search costs, that is basically finding out which product is of a quality product, would actually take a lot of time for the consumers. This results in a wastage of time. This also results in a lot of wastage of money because consumers could also be deceived at any point in time if marks are not necessarily protected. But on the other hand, if marks are protected, say for instance a consumer goes into a store, he knows very clearly which product to buy because largely he relies on a particular mark being imposed on a particular product. He knows that this mark kind of symbolizes a certain quality and the very fact that it originates from a particular manufacturer. So, in effect, granting trademark protection would kind of largely help out consumers, would avoid search costs, would ensure that there is no deception, and from a manufacturer's perspective as well, it is a good kind of an incentive for the manufacturer to maintain the quality and ensure that his products throughout are of a particular quality, because the moment the consumer identifies the mark with a certain quality, he is likely to keep buying the same product time after time. A good example would be a person buying a Samsung phone, a person buying an iPhone for a particular reason, right? Because they understand that it is of a particular quality, that it serves a particular end. If mark is not protected, then possibly consumers would be confused as to what to buy in the market. Similarly, John Stuart Mill's utilitarian theory could also be used to justify copyright. Now, how can this be used to justify copyright? Basically, if a certain monopoly period is not allowed for the author of the book who has published a book, then others can actually replicate the book and actually earn revenue out of it. But if the author is granted a certain period of protection, then it will allow him to actually come forward with the work, publish the work, and also recoup the costs and earn royalties by sales of books. But if no protection is given, that basically means the author would hesitate to actually publicly disclose his work. This, in the end, would basically mean that there will be very little work that will be published and circulated because there is no protection to the author, right? So Mill's utilitarian theory in effect kind of says protection to all the three different intellectual property rights would in the end result in maximum happiness for the maximum number of people, right? However, the utilitarian theory is not without criticism. The utilitarian justification of intellectual property right, on the other hand, is criticized because it has not been able to balance private and public interests. Private intellectual property restricts the use of ideas. Patent regime based on incentive system restricts the people other than the first person to register the idea from freely using that idea. Let's take the example of a person who's come up with a new technology. If a patent is granted to that new technology, then no one else can use that technology for a period of 20 years unless the person secures a license from the patent holder. Neither can modifications be made to such an innovation until the expiry of the 20-year monopoly period. If any additions or modifications have to be made to a new technology, then the person will have to wait for a good 20 years or secure a license and possibly make changes, which can actually be expensive for the society. Granting property rights to intangible ideas actually impedes the flow of knowledge and also prevents or delays downstream innovation. Though there is a system of disclosure under the patent system, it provides exclusive ownership to the person who owns the patent. Further, today the owner of the invention can restrict others from freely using the invention for a certain period of time. Had the patent system prevailed during the time when the wheel was invented, it would have restricted others from freely using the invention. This would have seriously restricted the development of mankind, as many important inventions, whether small or big, or improvements, immediately followed after the invention of the wheel. Thus, the intellectual property rights as such does not exactly allow free flow of ideas, and the restriction on the diffusion of technology in a way impedes innovations based on original patents. Further, there is also negative effect if it tends to have on the market as such. By providing patent protection for 20 years, what it invariably does is it eliminates competitors in the market and creates a monopoly situation that prevents others from entering the industry. This in a way leads to patent holder controlling the price of the product in the market, and the society may not benefit from such innovation. A classic example of this occurs generally in the pharmaceutical industry, wherein a manufacturer of a life-saving drug, generally when he has obtained a patent monopoly for a period of 20 years, would not allow others to actually enter the market. This basically results in a situation where the patent holder can effectively keep increasing the prices of life-saving drugs. And with drugs, everyone knows that if you do not take the drugs, you will not be able to actually get cured, or probably it could be fatal, right? So this is the kind of price that one would actually pay for having an intellectual property system which is fairly restrictive on competition, fairly restrictive in terms of downstream innovation, fairly restrictive in terms of flow of information, right? With that, we come to the conclusion of the utilitarian justification of intellectual property. Next, we basically look into Locke's labor theory. One of the powerful bases for justifying intellectual property right lies in the belief that a person deserves the fruit of his labor. This was largely espoused by John Locke in his second treatise of government. Locke basically asserts that all that is in nature is provided by God, right? And it is available to all men as it is held in common for the benefit of all. Basically, to expand on what Locke believes is all that is available in the nature is largely basically created by God, and this should not be monopolized or held as property by a particular individual. In fact, it should be allowed for everyone to enjoy what is actually given by God. So he says no individual can have prior claim over substances that are available in nature as it is meant for the enjoyment of the entire humanity, right? Now, but Locke puts in a certain rider here. That rider basically is, Locke asserts that when individual exerts his labor over resources, he can basically claim it as his property because he has added value through his labor. Say for instance, if an individual digs the ground, and while digging he manages to kind of get gold, then according to Locke, that gold would actually become the property of the individual because the individual was the one who actually used his labor to dig and find the gold, right? So Locke's version of this labor justification is based on the assumption that each individual has prior property rights in one's body, right? He says that every individual has a property right in one's own body. So according to Locke, labor exerted by an individual is his own property as he is the owner of his body. It is impossible to separate labor and its product. So once the labor is mixed to something that exists in nature and it is transformed, then it is absolutely difficult to kind of make a differentiation as to what existed in nature and whether it is mixed with some kind of a labor. Here, only the person's effort is relevant, no less to others, as a precondition for property acquisition. So the moment a person mixes his labor in getting something that already exists in nature, he has property rights over it. Thus, anything an individual mixes his labor with becomes his property. No one has a superior or conflicting claim over it. Now, Locke would readily grant patent right if an individual exerts labor to come up with an innovative product or a machine that is useful. For instance, James Watt used his labor to develop and improve steam engines that could be used in locomotives. Watt's invention added value and spurred the growth of the economy. Locke's labor theory can be used to justify patent protection for Watt's steam engine, as he had mixed his labor to develop a new technology. As per Locke, an author, painter, photographer, musician who has exerted his labor to express his original thoughts in the form of a book, paint, photo, or music album should readily be granted a copyright. But Locke also kind of brings in a certain proviso to this, saying that we need to have and we need to look at certain conditions. What exactly is that condition? He calls it as a sufficiency proviso. According to Locke, property rights can be allowed only if it does not deny the others of resources existing in nature. If there are enough resources available in nature, then property rights can be claimed over resources when a person exerts labor over it. Locke expresses concern that if a particular substance is not available in abundance, then property rights over it would deny others of access to that scarce resource. In such instances, an individual who has exerted his labor over the scarce resource cannot claim property rights in it. Thus, Locke would have an objection if natural phenomenon or natural resources like genes are monopolized, even if an individual has exerted labor to identify or discover its existence, as it would prevent others from using it for a certain period of time. But Locke's labor theory is not without its criticism. According to Robert Nozick, fruits of labor is usually valuable, and property rights enables the laborer to appropriate this value. Nozick clarifies that Locke allowed private property right only if there is enough left for others from the common pool of resources. He explained that Locke only allowed private property rights if it does not cause harm to others and there is enough left for others. For instance, if natural resources are scarce and too many people are dependent on its availability, then if a person has mixed his labor, he cannot claim property rights in it, as it would deprive others of it. Thus, granting a patent to a person or an entity that limits access to others would certainly be a matter of concern to Locke. According to Locke, natural resources do not have any value until an individual exerts his labor on it. Locke suggests that 99% of the value is created when labor is mixed with a naturally existing substance to create an object. However, this is not plausible when labor is mixed with naturally existing substance that does not result in transformation of the substance. What am I talking about? For example, a person called W.R. Grace claimed a patent on neem extract. All that Grace did was to identify exactly which chemical component in the neem plant had the insecticide property and extracted that component and claimed patent over it. Here the labor is mixed with what already existed in nature. Further, Hettinger criticizes labor theory because it fails to take into account value added to a production by contributions made by others in the evolution of that product. For instance, although multiple people might have contributed to the evolution of a technology, labor theory may account for only the value added by the most recent contributor. For instance, steam engine was not invented by James Watt alone, but he was definitely involved in improving the technology. However, prior to Watt's invention, there were many others who contributed in the evolution of steam engine, but unfortunately it was only Watt who was able to get the full market value for improvements in the steam engine. So with that, we come to the conclusion of Locke's labor theory. Now let us quickly move over to Hegel's personality theory. The personality theory has been used to justify intellectual property rights, although the person who came up with the personality theory never necessarily kind of used it to justify intellectual property right. According to the personality theory, any work or invention would belong to its author or inventor because it is the manifestation of the creator or inventor's personality. The person who espoused this theory is George Wilhelm Friedrich Hegel in his book Elements of Philosophy of Right. states that the individual's will should be given more importance compared to other elements that make up an individual. He identifies the personality as the will's struggle to actualize itself. According to Hegel, personality is a reflection of an individual's will. Hegel basically gives prominence to the will compared to external property, which is a manifestation of the will. Property, according to him, becomes an expression of the will. According to Hegel, society accepts the external manifestation of an individual's personality as property. Thus, when an individual expresses himself through his work, it is nothing but an external manifestation of his personality. Property rights are vested in the external object purely because it is the resultant manifestation of the individual's will. Labor is the means by which the will occupies the object. Hegel believes that this external manifestation, which is seen as property, cannot be alienated at any point in time, as it is a reflection of the self. Hegel's personality theory can be used to justify claims by authors, musicians, artists, sculptors, photographers in their work. An author's personality is manifested through his or her work. Books written by authors are external objects through which their inner personality, that is, their feelings, emotions, experiences and imagination, is manifested. For instance, the Harry Potter series is an external manifestation of J.K. Rowling's personality. The book itself is an expression of the will and part of the personality, and as such justifies right to property. Similarly, an innovative technology is a manifestation of the inventor's will and as such merits a property right. But Hegel's personality theory is not without criticism. The problem in applying personality justification to intellectual property would be in identifying whether there is a personality stake in the particular object, which is the external manifestation of the will. Further, Hegel's proposition that works are external manifestation of personality also poses problem within the realm of intellectual property rights. A person who writes either handwritten or typed a book by copiously copying the works of others, or a painter who imitates another painter's work, would have done so by manifestly expressing his personality regardless of the fact that he is borrowing from someone else. The writer or painter, in copying or imitating, has used his skills and abilities and expressed his will, and as such would have a property right in it. This would be counterproductive to an intellectual property regime, as it does not recognize the imitator as a property right holder. Now, with that, we actually kind of conclude all the three theories that we are talking or discussing about, right? So, to recap, we initially discussed John Stuart Mill's utilitarian theory, which talks about maximum good or the maximum number of people. Intellectual property rights actually kind of does maximum good to the maximum number of people because it provides an incentive, right? Further, the Locke's labor theory is entirely based on the fact that a human being mixes his labor with something else, and as such there is a property right in it. So an inventor who comes up with an innovation has mixed his labor with something else, and as such deserves property right. And Hegel's personality theory is nothing but an external manifestation of an individual's personality. Thank you.